One RFE, one sudden security hold, one regulatory change, or one headline-grabbing bill from an attention-seeking politician could quietly threaten years of your hard work in America. We are breaking down everything you need to know. Check the timestamps on your screen to jump straight to the segment that impacts you more. Right now, thousands of international STEM professionals are facing exactly these pressures. It feels like the ground is shifting beneath your feet. A frightening RFE that could derail your green card. National security holds freezing your OPT or H-1B. DHS quietly rewriting the rules around OPT. And noisy, low-probability bills in Congress that stir up anxiety but have almost no chance of becoming law. Pure election season theater. Here's the hard truth. The window to secure your future is closing faster than most people realize. Every month you wait, RFEs become harder to overcome. Vetting holds grow longer. Regulatory changes tighten, and your best evidence gets older. But I am not here to dwell on fear. I am here to give you the exact blueprint to take back control. The strongest self-petition pathways, EB-1A and EB-2NIW, still work today for well-prepared cases, even as they face more scrutiny. Those who act decisively now are the ones who will still have strong options 6 to 12 months from now. This report breaks down the 4 most pressing threats this season and the practical strategies you can use right now to protect yourself. The law offices of Chris M. Ingram track these battles daily. We help our STEM clients cut through the theater, ignore the distractions, and turn uncertainty into clear, winning strategies before the window narrows further. Let's dive in. We'll walk through each threat together and show you exactly how to protect your future. If you're feeling the pressure right now, stay with me. Your breakthrough starts here.
How to beat an RFE. Imagine opening your USCIS notice and seeing those 3 letters, RFE. For many international STEM professionals pursuing EB-1A, EB-2NIW, or O-1A, that moment triggers pure panic. The deer in the headlights freeze. Your heart races. Years of publications, patents, and breakthroughs suddenly feel like they're slipping away. You wonder if this is the beginning of the end of your US career. The data confirms the fear is real. In recent quarters, EB-2NIW approval rates have dropped as low as 35 to 55%, and RFE rates for both EB-1A and EB-2NIW now hover between 40% and 52%. Many strong cases are challenged not because the evidence is weak, but because it wasn't framed, selected, and defended with precision. The emotional toll is brutal: sleepless nights, constant second-guessing, and an 87-day clock ticking down while your family's future hangs in the balance. One AI researcher told us the RFE felt like watching my entire American dream unravel in a single paragraph. Here is the turning point. Beating an RFE is not about dumping more evidence. It is about surgical skill, knowing which pieces are strongest, which ones are harmful and must be excluded, and how to reframe the entire narrative so every response directly answers the officer's concern in a legally bulletproof way. We have seen this transformation repeatedly. One client received an RFE questioning the national importance of his work. The previous team submitted a massive volume of documents that diluted the impact. Our team removed the weaker material, strategically repositioned the strongest evidence, and built a clear, focused response. The case was approved shortly after. Clients described the relief as a weight lifted, renewed confidence, and the ability to focus on research instead of fear. This is why the law offices of Chris M. Ingram have built our reputation on beating RFEs that other firms thought were hopeless. If you have already received an RFE or want to file in a way that dramatically reduces the chance of one, the difference between panic and victory comes down to choosing the right team from day one. And if you're a student or recent grad relying on OPT, the rules are changing behind the scenes. Stay with me. What's next is critical for your survival in the US.
Okay, Agent 9. You have a new active client. You know what to do.
I am working on the client case now.
At the law offices of Chris M. Ingram, we do whatever it takes to get our clients approved.
Her case is looking good.
Now move quickly. Agent 9, time is ticking.
I have been with her every step of the way and walked her personally through each question.
We never let obstacles get in our way, because the result is always worth it.
We have got this. This is what we do.
Another satisfied client. Another mission complete.
Another satisfied client.
But we're not done yet. Another case just came in, so come on. We have work to do. Let's move.
Need help with your visa? Book your free consultation now at breakthroughusa.com. We are with you every step of the way.
The end of OPT, STEM OPT. For F1 students and recent graduates, one of the biggest looming threats is the potential dismantling or severe restriction of the optional practical training program. DHS is actively reevaluating the entire practical training framework under Spring 2026 Unified Agenda Rulemaking, RIN 1653-AA97. The review focuses on fraud prevention, worker displacement, national security screening, and tighter SEVP oversight. Proposals under discussion include narrowing qualifying STEM degrees, shortening or eliminating the 24-month extension, and imposing stricter employer verification, with some voices even calling for outright elimination. The stakes are enormous. OPT has been the critical bridge for hundreds of thousands of international graduates. Without it, many would be forced to leave immediately after graduation. University administrators, NAFSA, Stuart Anderson of NFAP, and economists like Giovanni Perry have warned of sharp enrollment drops and innovation losses. Increased site visits and scrutiny are already creating anxiety for current OPT holders. You are not powerless. Maintain impeccable compliance records and prepare self-petition strategies as backups. Attorney Chris M. Ingram and our team are helping clients build compliance shields and alternative pathways. By initiating an EB2 NIW or EB1A early, you create your own safety net, completely independent of the OPT system.
Politicians playing immigration games. While regulatory reviews threaten OPT, noisy legislative proposals in Congress create another layer of anxiety and distraction. Bills like the End H-1B Visa Abuse Act of 2026 call for a 3-year pause on new H-1B visas, drastic cuts to the cap, huge minimum salary floors, and sweeping restrictions. These headline-grabbing proposals are classic election season theatre. They generate noise and fear, but have almost no realistic chance of passing in their current form. Still, the uncertainty is real. Employers are hesitating on sponsorship plans for fiscal year 2027, and professionals on expiring statuses feel heightened pressure. Stuart Anderson, NFAP, has called such measures self-inflicted wounds. Tech leaders emphasize that immigrants drive a disproportionate share of innovation. The true risk is paralysis caused by manufactured drama. Potential solutions include positioning for highest wage roles where possible and accelerating self-petition filings. Our team helps clients develop contingency plans that reduce reliance on the H-1B lottery and cut through the political noise. Next, I'm addressing something incredibly serious that no one wants to talk about. What happens when your nationality puts your entire journey on indefinite pause?
Paused visas. One of the most frightening realities is this: your nationality alone can now put your entire U.S. journey on indefinite pause. Since late 2025, USCIS has dramatically expanded national security vetting holds on applicants from 39 high-risk countries, including Afghanistan, Iran, Venezuela, and many others. These holds affect OPT/STEM extensions, H-1B changes, and employment-based green cards. Even applicants with clean records, strong employers, and advanced degrees face cases frozen for months with no clear timeline. The human impact is devastating. A talented semiconductor engineer watched his STEM OPT extension vanish into a black hole for over 7 months. His employer reassigned critical work, and he lived every day wondering if he would be forced to leave mid-career. Many describe the same paralyzing uncertainty, feeling powerless while their American dream is held hostage. Experts are sounding alarms. Stuart Anderson warns that overly broad restrictions risk damaging U.S. competitiveness. The American Immigration Lawyers Association highlights the lack of transparency, and Brookings scholars note the chilling effect on retention. You do not have to accept the deadlock. Our team doesn't just submit more paperwork. We craft compelling requests that demonstrate genuine U.S. national benefit and push aggressively for case-by-case resolutions. We have helped many clients break through holds that initially appeared insurmountable. When external forces feel unpredictable, EB-1A, Extraordinary Ability, and EB-2NIW, National Interest Waiver, remain powerful tools fully under your control. These pathways require no employer sponsorship and continue succeeding for strong STEM professionals advancing U.S. priorities. Our firm specializes in turning your achievements into compelling, approvable cases, even amid tightening rules.
Client voices. The power of the right team. Riaz shared, Alexandra is my caseworker and deserves a 5-star rating. She is detailed and realistic. She sets clear expectations. Her answers are precise and easy to understand. She removes confusion and keeps the process moving. Alina. David Tromp, Miguel Farias, Onur Yildirim, and the whole team are outstanding. High level of expertise, strategic thinking, and attention to detail. The whole team remained fully committed and never gave up. Perva. I especially want to recognise Lazaro Carrillo. He took the time to truly understand my background and the specifics of my situation, which made a huge difference.
Top 5 searched STEM immigration concerns. I just received an RFE. What should I do? Don't panic. The right strategy and evidence selection can turn it around. We specialize in building winning RFE responses. With DHS reviewing OPT, should I file my extension now? Yes, while maintaining impeccable records. We help clients prepare strong compliance and backup strategies. How real is the threat from new H-1B restriction bills? Mostly political theater, but the uncertainty is real. We develop contingency plans, including accelerated self-petition routes. How serious are the high-risk country vetting holds? They can cause major delays, but our strategic approach has helped many clients secure resolutions. Facing all these threats, how do I secure my long-term future? The smartest first step is a free EB-1A or EB-2NIW eligibility audit with me. We turn these challenges into personalized breakthrough strategies. The U.S. STEM immigration landscape this season is intense and uncertain, but filled with opportunities for those who understand the dynamics and act with clarity. You've worked too hard, sacrificed too much, and brought too much value to this country to let an RFE, a political bill, or a bureaucratic delay dictate your family's future. At the law offices of Chris M. Ingram, we serve as the safe harbor that turns these challenges into genuine breakthroughs. Take the next step today. Go to breakthroughusa.com right now, sign up for your free consultation, and let's craft the strategy that puts you back in the driver's seat. Your future in America is worth fighting for. Let's go win it.